Hello students, my name is Udana Soisa. I've done at law. I've been a lecturer with the University of London for nearly a decade now. In this short series, this 5 minutes series, we will learn the basics about various subjects within the University of London syllabus, ranging from contract law, criminology, jurisprudence, criminal law, international law, even to areas such as legal systems, public law, trust and equity, property law, and etc. So I hope that you stick with us and learn to think and analyze through these little videos we are bringing to you. So in today's lecture, we will focus on the English legal system as a syllabus. So in your first year course of English legal system, what are the connecting issues? In fact, what is this English legal system? If you can just close your eyes for a second, if you can just close your eyes and imagine this, if you can imagine a courtroom, you can see here, we have a courtroom. What do you see in this courtroom? You see a judge, you see a jury, you see the defendant, you see the claimant, you see the lawyers representing, you see the judiciary. This entire court system, this entire court structure, this is your syllabus. In your syllabus, you will learn about judges. How independent are the judges? How diverse are the judges? I would really recommend you to focus on those two questions. The judicial diversity question, that's a great question. How diverse is the English judiciary? How independent is the English judiciary? What are theories? What are certain theories that the judge can use? There are two theories which are often questioned in your exam. First, judicial precedent, also known as stare decisis, standby decision. You need to understand the difference between ratio, the reasons of a decision, and obiter dictum, other reasons. You also need to realize the second legal concept, which is statutory interpretation. What are the classic statutory interpretation rules? The literal rule, the golden rule, the mischief rule, the purposive rule. However, now we are focused more towards EU approaches, human rights approaches. You should focus on the cases such as Guyton versus Gordon Mendoza, Pre-A. In those cases, you can see that sometimes the courts do read in, read out, read down. But there are many aspects of legal reasoning that you need to focus. I would tell you to focus on two aspects. One is statutory interpretation. How can a judge interpret statute? Secondly, judicial precedent. Can judge go against their own decision? Are they bound by courts which are parallel? Are they bound by courts which are higher? When can they go against their own judgments? When can they go against the judgments of courts which are superior? Is that allowed? What were some of the behaviors by Lord Denning? How can this all be linked to human rights? Especially after Human Rights Act. Then you can also link all of this to EU, especially after Brexit. So I think all the students have a contemporary knowledge about these realities. So you need to add this to your answer. Many of you guys have a basic understanding of those classic views. But then again, this is where your textbook is coming to play. If you look at Holland and Webb for English legal system, and even you can add things from your public textbook, Lesu and Sunkin, which I think is really helpful, especially for statutory interpretation and judicial precedent. Finally, there are two other questionable areas: the civil justice system. What are the problems with civil justice system? There are CCD, cost, complexities and delays. Then there is again Lord Wolf reforms. Then again there are reforms introduced by civil procedure rules. In terms of criminal procedure, what is the role of jury? Should jury trials be abolished? What are problems with criminal justice system in terms of miscarriage of justice? These are often questioned in your exam. Right? However, my favorite areas are judicial diversity, statutory interpretation, judicial precedent, and finally, a really great area would be judicial selection. As per your paper for this year, you are only expected to do two of those areas. Then you have the case note. This year's case note is fairly simple. And as per this year, you have the Ivory Act of 2018 as your statute. And the examiner will give you a scenario to apply the Ivory Act 2018. And again, you are not expected to talk about the rules of interpretation. You are expected to apply the act. So if you have decent English, you should be able to pull through this English legal system exam. All the best for upcoming exams, and thank you for watching our videos.